Hey, everybody. Welcome to Thursday night. Hey, everybody. Thursday night here. John Skiba here, the Consumer Warrior YouTube channel, here once again. This week, man, it's flying by. We should always do a holiday on Tuesday because that seems to make things go by a lot quicker here to Thursday night. Again, I'm John Skiba. I am a consumer protection attorney and a consumer bankruptcy attorney in the state of Arizona. And I founded the Consumer Warrior YouTube channel years and years ago to provide information for people who are dealing with serious debt issues. I always used to say we don't just dabble in debt. This is for people who are dealing with serious things like debt collection lawsuits, wage garnishments, bankruptcies, and all the other horrible things that are out there. And so my whole point is just to provide some information, maybe give you some tips and some strategies that you can use to try to get to try to get the debt situation under control and get these creditors off your back and allow you to move forward and be more productive with life. So like I do each and every week, I just let people know that while I am a licensed attorney in the state of Arizona, I'm not licensed anywhere else. I had a number of people set up consultations with me here in my law office in Arizona this week. And unfortunately, we have to cancel those because I'm not licensed in other states. I can't represent people in other states. So I just provide general information here on YouTube. You should not take this as legal advice. As I say each and every week, don't take your legal information from some guy or gal on YouTube. Find an attorney in your jurisdiction who can give you some legal advice. If you are in the state of Arizona, my number is streaming across the screen here below, and my contact information will be below that. And so you can set up a consultation. I do free consults for people who are residents of the state of Arizona, where we can talk about any specifics you have. Now, the way that we do this is you can put, if you have a question, put it in the chat section. If you're on YouTube, I think it also works because we're live streaming this to Facebook as well. And I'll put the question up here on the screen and we can talk about it. Like I said, I don't know all the laws everywhere else, but I can at least give you some resources and point you in some directions as far as that might be helpful. So, we have to start off with Dave, who's showing up for the first time, for the first time in a while, providing some great support to the channel and letting us know that you had a heart attack and a triple bypass. I'm glad you're doing better, man. Welcome back. That's a scary, serious thing. So I'm glad you're doing better, and you're better enough to be back here messing around on YouTube. So she'll let you get back online. Awesome. I look rather gaunt. That may be the nicest thing you've ever said to me. If you haven't been here for a while, I've told people in the past kind of about it. It's kind of funny being on YouTube because I've been on it for years. And so I see myself age over the years in real time and all these things on YouTube, and they're there forever. In the last year, it's almost been actually a full year. July 18th was the day when I started this kind of weight loss journey that I did. I had a gastric sleeve surgery. I think I've talked about this on the channel before. I know this isn't why people came, but just so you're aware that I am well. I'm actually better than I've been in a long time. Many of you know I played college football at BYU. I was an offensive lineman. That was a great time in my life. It gave me a lot of really, really bad eating habits, and it was just causing all kinds of issues with my health. So I had this surgery last July. I'm down over 100 pounds and feeling better. And like I said, looking gaunt. That's one of the nicer things you said. So Dave, thank you for supporting the channel, and I hope you are feeling better and back at things. All right, let's see what Derek has to say. He said, if a credit card companies have sold my debt to a junk debt buyer, can I request the original creditors move my account out of collections because they received a payment from someone else? So it's a good question. Kind of gets into the complexities of not only what the debt buyer and the original creditor, what their agreement says. There's some Fair Credit Reporting Act type issues here. But so the junk debt buyers, the portfolio recoveries, the Midland Fundings, the Unifunds, National Collegiate Student Loan Trust, all these junk debt buyers, they go out and they buy these old charged off debts for pennies on the dollar. And they do pay some money to the original creditor. But the question is, can you ask the original creditor to move the account out of collections? I'm assuming you're meaning on your credit report. You could file a dispute, but I mean, what the most they would do is take it out of like as a derogatory account, but they could still put a notation in there. And the notation usually is in there that it was sold to a third-party debt buyer. That may be the most you're going to get out of them. It's not going to impact the credit score or anything like that significantly. Best case scenario you're going to get is it's going to say settled for less than amount owed, and I don't even think you'd get that. It's just going to state that it was transferred to a third-party debt buyer. So hopefully that's a little bit helpful, but there's not a lot you can do there. The one thing you've got to be careful of, and that you can follow up on your credit report, is often when a junk debt buyer purchases the debt and then they start reporting it on your credit report, they will re-age the debt. So instead of them showing the date that the debt went into default or the date when it was originally open, they act like that day one should be the date that they bought it. And you shouldn't allow them to do that. You can raise an objection to that specific issue. All right, Steve says, hi, John. In my state, a lawsuit doesn't have to be filed with the court to start the lawsuit. They have 1 year to file with the courts. After 1 year, if it's not filed, it's dismissed with prejudice automatically. PRA, Portfolio Recovery Associates, is who that is. They are a junk debt buyer, sent me a notice of dismissal without prejudice and costs to either party pursuant to the rules of civil procedure 41.01 on the 364th day. According to 41.01 notice of dismissal, they can do this before service of the adverse party of an answer or a motion for summary judgment, or both parties have to agree to this. I did file an answer. Does this mean that they can not dismiss without me agreeing to it? So this is a good question, and you're citing to rules of civil procedure. You know what? I have my rules book right here. So I can tell you in Arizona, if people happen to be in Arizona, the rules usually line up is what you're going to notice. Like how you're in your state, it says 41.01 is the rule. I believe the 41 is the rule here as well that deals with, yes, there it is. Rule 41. Dismissal of actions. It's the same. So rule 41 in Arizona, and in the federal rules, I believe it's the same with 41. And what it does say, it says if a creditor or a plaintiff is what it's going to say there. If a plaintiff files a lawsuit and the other side does not answer, or there's not some type of motion pending, that party can unilaterally dismiss the lawsuit without the defendant agreeing to it. So they can do what you're saying that PRA did here. They dismissed because they told the court that you hadn't filed an answer. If you did file an answer, and this is true in any civil suit, if the defendant files an answer, the plaintiff can't just say, hey, never mind, I'm backing out of this. The plaintiff has to get you to agree to it. You have to stipulate to dismissal, or they have to file a motion to dismiss and give you a chance to respond to it. And the reason why is because now you have skin in the game. You know, if you're a defendant, you've been served, you drafted an answer, you filed it, or you hired an attorney, you paid the filing fees with the court. And so now they can't just back out without either you agreeing to it or the court just signing off on it. So you can, you know, what that does is that gives you a little bit of leverage. Like usually I say I wouldn't stipulate to dismiss unless it's done with prejudice, meaning that it can never be refiled again. And I require that they have a signed settlement and release document stating that not only can they not refile it, but the debt is extinguished. It has gone away completely. So that's what and so in your case, let me see here. So if you have filed an answer, so if the court has not dismissed it, you should file a response to their motion and saying, I am here, I did file an answer, and then I would file that response to the motion, let the court know that you filed an answer, and the court should see this. But the courts deal with a lot of cases. That's what you have to remember. And so sometimes things like that, they'll just see it, you know, and dismiss it. I would let the court know, and then I would immediately reach out to the attorney for PRA saying, hey, I filed an answer. I will stipulate to dismiss if you agree to dismiss with prejudice, and which sounds like the rules that it might trigger that anyway with the rules in your state. And you want to release saying that the debt is done away. So you can use that to your advantage there. So, all right, let's see what J&L, I'm not even going to say it, some mom. Okay. I chose not to reaffirm furniture during Chapter 7. If the company wants it back, how long does the company have to contact me? I can tell you this. I have filed a lot of Chapter 7s. I've been doing this almost 20 years. In October, early 20 years. I have never had a furniture company come back after furniture that has a collateral in it. It's funny because if you know the Dave Ramsey story very well, that's why he filed for bankruptcy, is because they were coming to repossess furniture, and he was trying to stop that, which he did. So I have not seen that. In Arizona, we don't see that a whole lot with creditors that have a security agreement. Not only that, reaffirmation agreements, at least in Arizona, they're not going to sign off on that on a furniture item. Something you might be able to do, particularly if you use an attorney, you might want to talk to your attorney, and you could go in and do what's called redeeming it, or redemption on those contracts. And what that is it's where you can essentially pay the value of the furniture rather than what's owed on it. So if you have a couch that was $2,500 brand new, and you have a loan that you're paying on it, but now it's worth $500, through the Chapter 7 bankruptcy, you can file a motion to redeem that property, and you can pay the $500 all at once, and then the rest of the debt is wiped out. So if they have a true security interest in there, they could. There's no time limit really for them to come after you, other than maybe the statute of limitations. But they could try to execute on that if they got really aggressive on it. Like I said, I don't see them do that very often. My recommendation would be to go and see if you could do some type of redemption and redeem that to get that squared away. All right, let's see here. Janice says, I'm judgment proof. Pro se, I have a pretrial conference July 28th. Discovery is due July 14th. What do I need to provide? What if I do nothing? What about forcing arbitration? And then her follow-up was that LVNV is suing you for $20,800. There is a bill of sale and assignment. There's no purchase agreement. 71 years old. All right. So, let's talk about the pretrial conference. Pretrial conference in Arizona is usually a fairly informal thing, and they're typically done via Zoom or over the telephone now, depending on the court that you're in. They could be in person, but really the pretrial conference is typically, this is going to be in Superior Court in Arizona because you're over $10,000 that's in dispute. The pretrial conference is really when the judge becomes kind of aware of your case for the first time. They're going to give you some dates as far as like discovery deadlines. They're going to talk about compulsory arbitration, which is required in Arizona. So it's going to be something like that. So the hearing itself is not a big deal, but it's a super big deal if you don't show up. If you don't show up, the court will just enter judgment against you. So if you show up, it's really just a conversation between you, the judge, and the other attorney. You're not going to be arguing really the legal merits of the case or any defenses. It's more of kind of a housekeeping thing where the court's just setting up some dates. They want to know if the parties want to participate in mediation. The court may assign an arbitrator at that point and just give you some dates. So it's literally usually like a 5 to 10 minute thing. It's not a big deal. Other than it's a big deal if you don't show up. So make sure you show up. As far as discovery, so the discovery, the initial disclosures, if you haven't provided that, the rules require that an initial disclosure be exchanged by the parties. This lays out, it's Rule 26.1 under the Arizona Rules of Civil Procedure. I also have a tutorial. I put a link at the top of my thing here as far as the disclosure statements. If you're a member of the consumerware community, you get access to all my templates, all my tutorials, forms, everything. There's a link there at the top of the chat section. That has all the information, and there's one specifically on Arizona disclosure statements. That's something you'll need to do. You have to provide essentially your side of the facts, any defenses, list of witnesses, list of any documents you might have. And it's important to provide that. So go ahead and check that out. As far as forcing arbitration, if you have an arbitration clause, that one thing you need to go back, and that they probably provided you with an initial disclosure statement that would, you need to go through there and see if there's an arbitration clause. If there is one, you may be able to ask the court to force private arbitration. That is a possibility. And if you do nothing, you brought up judgment proof. We talked about that before on the channel. It's rare that I recommend people do nothing, just because even if you're judgment proof today, maybe 5 years from now, you won't be. And then all of a sudden this judgment has a ton of interest and it's a big problem. So I would usually recommend still taking some type of action. But if you do nothing, if you don't show up to the hearing, clearly you filed an answer. So you're finding out about the pretrial conference. But if you do nothing, the court, if you didn't show up to that, the court will enter judgment against you, and then they can lien property. If you're retired, you said you're 71. If you're retired, they can't go after your Social Security. That's exempt. But they can still try to collect and kind of be annoying. So something to be very careful of. Recommend you set up a consultation if it's something where you want to kind of decide which route to go. So, all right, let's see here. Alex, down in Yuma. Alex, summertime is here in Arizona. We've had a mild summer for Arizona. And I looked at the forecast today in Phoenix. It's over 111 every day for the next week, and it's going to be 116 on Monday, and it's going to be horrible, and we're paying for it now. Alex, all right, let's talk about your question here. Do contractors who still have outstanding jobs have to list those jobs in their bankruptcy schedules? That's a good question. So I guess the places where they could be listed, and I guess it depends on your question's probably a little more complex than maybe at first look. So it depends on if the contractor themselves is filing for bankruptcy, like the individual, or if like their company is, like they're like an LLC or corporation. If the contractor is, or let's say that they're a sole proprietor, they're just out there doing their thing. If a contractor files for bankruptcy and they have outstanding contracts that they have yet to be fulfilled, we call those in the law executory contracts. And Schedule E of the Bankruptcy Code is where we have to list any leases or executory contracts. And so, yes, those would be disclosed there. And in a bankruptcy Chapter 7 type setting, you can either assume or reject executory contracts. Same with leases. So you can say, hey, I'm going to keep this contract and still perform under it, or no, I'm going to reject it and get rid of it. What we see sometimes with contractors or business owners, they have like a long lease that they're going to owe on, or there's some contract that they don't want to try to, they're not able to fulfill. They'll reject those, and then they go away with all the rest of the debts. So hopefully that, okay, so you're saying your contractor's LLC is filing for bankruptcy. You may want to get an attorney to look at that for you. You can tell me too if the LLC is, it depends on whether they're filing Chapter 11 or Chapter 7. If they're filing Chapter 7, that means that they're just closing the doors on this thing. They're going to liquidate any assets and try to make any distributions that they can. If it's Chapter 11, they're going to try to restructure, and much, much more complicated. So you may want to find that out, and it may be worth looking to file a claim. It's kind of outside the scope here, but it's a good question. Something you got to find an attorney there in Yuma. There's a lot of good bankruptcy attorneys there in Yuma that can help you out. So let's see what we got here. Dave, 67. I don't think it's ever 67 in Arizona. Not at nighttime, not in the winter, not anything. It's just horrible. It's just constantly horrible. So, and that's nothing compared to what Alex down by Yuma, down there by the border, they make it look mild up here in Phoenix. So, all right, y'all. Hey, that'll be it for today. But hey, I appreciate everybody checking in. And Dave, glad you're back at it. Glad you're doing better with your health. Any other questions, go ahead and put them in the comments. I do come back and I can take a look at those later. Again, check out the Consumer Warrior templates, the tutorials, all the different forms and templates that I have there. The Consumer Warrior University is there. Check that out. I know that they can be of help. We've had a lot of good feedback on those. And that being said, I think we're going to call it a day. We'll catch you next week.